Your Honor.
We had one juror delayed, but as soon as she comes in, I think it's a woman, we'll start. But I see the dispute you have about, is it Exhibit 38?
It is Exhibit 38, Your Honor.
Right. Just explain to me, Mr. Axelrod, what this document is and how you intend to use it.
Your Honor, what it is a summary. Well, let me start at the beginning. Every time someone leaves the country and then comes back, the Customs and Border Patrol swipe their passport. I'm sure it's happened to you. You've seen it. Well, all those records go into a database. So if someone needs to enter in a passport number or a person's Social Security or other identifying information, they can produce a report. That's what's been done in this case. The Treasury Department actually has produced a report of all the times the defendant's passport was swiped coming back into this country.
So this is the first document, which is marked Exhibit B, that is the certification that you've gotten about the records by a custodian. Is that right?
That is correct, Your Honor.
The next page says official use only text, TECS, Roman numeral 2 information.
Correct.
Passenger activity report selection criteria. And refers to Pat Shelow. I presume somehow that'll be correlated to this Patrick Shelow. And the date of birth is July 11th, 1952, right?
That's correct.
All right. And then there are 5 pages. The last page only has 2 blackout marks. And the intervening 4 pages, does this have historical data as to the history of this person and going in and out of the United States?
That's correct, Your Honor. What that is that is a record. Those pages you're looking at where it says Patrick Shelow and then it has information. Those are the records of when he came back into this country.
When he left and when he came back?
Well, actually, that just records when he came back.
Oh, doesn't
They don't
have
swipe your passport when you leave in most cases.
Right. Okay. You need a passport to get on the airplane, but you don't have to show it to Customs.
You don't have to show it to Customs.
So this is when he comes back.
Correct.
Okay. All right. And Mrs. Drone, your objection is, I read your letter quickly just this morning. Your letter is based on that you don't think this, you don't object to self-authenticate. You don't object to authentic.
I do not object to self-authentication. That's correct. And nor do I object on a confrontational clause basis. It's just all the facts that Mr. Axelrod just represented are facts conditioned precedent to establishing the exception to the hearsay rule that this applies, that would apply to this. And Your Honor raised a point that was a point of mine. I mean, again, I'm not suggesting any impropriety, but I don't know unless somebody tells me how we know for certain this is this Patrick Shelow.
Well, Your Honor, it's his birth date and it's his passport number.
Right.
And Your Honor, I would suggest there's as you know, under Rule 104, the court isn't governed by the normal hearsay rules in considering questions of admissibility, which is the United States versus Bougera Lee case, which, if I can find my folder, I would give you a case site. It's from 1987. And if you look at if Your Honor was concerned that this wasn't really a public record, Agent Lyons could certainly testify as a preliminary matter about the way in which this data was produced and the way the records were kept, which would satisfy that public records exception. All I intend to do is, once that record's admitted, have Agent Lyons say that it is what it says, it's a summary of that report, and then we're going to talk about the times that Patrick Shelow was coming back into the country. That's it.
Well, do you have evidence to put in the record that this is his birthday?
Yes, Your Honor.
How are you going to prove that?
Through Agent Lyons.
How does he know?
Well, he's consulted public records.
Well, what public record?
Your Honor, his driver's license, his home ownership, the mortgage that he filed to purchase both of his
From your
homes.
investigation of other records.
Yes, sir.
It shows this is his birthday?
Yes, sir.
Your Honor, maybe I could short circuit this. If Agent Lyons knows the mechanics in which this is created and what it purports to reflect, and then I obviously have the opportunity to cross-examine him on those points, then I don't really have a problem at this point. It's just I wasn't certain how the government was going. I mean, my concern was that it was going to be admitted, and then Agent Lyons was going to be giving information from a report that he knows nothing about, because I didn't understand that he had anything to do with the Treasury Department or had any knowledge of the creation of this, how this report was created. If his representation is that he could answer questions that I would ask him about this report, then that's fine. I don't have a problem.
And that will certainly all be hearsay information, because Agent Lyons had nothing to do with the creation of this report, but he knows how it was done based on who he spoke to.
Well, does that, I mean, we're having a little Rule 104 hearing right now.
We certainly are.
Does that solve your objection?
Yes, sir.
Okay. All right. Well, then we'll withhold any ruling on it until Agent Lyons testifies about it. Okay.
Okay. Thank you, Your Honor.
All right. Thank you. Okay. All right.
David, this is my third.
All right. Mr. Cedrone filed another motion entitled "Motion to Dismiss Indictment for Failure to State an Offense." Okay, well, I haven't read it yet, but we'll talk about it at the end of the day. Now, just so you all know, we're going to break for lunch somewhere between 12 and 12:15, and I'll have the jury come back probably around 1:45, 1:45, so it'll be about an hour and a half.
Okay.
Janice, can you find out from Joanne what the story is? If we're missing, if we're just waiting for one juror.
38.
Sorry. So as soon as the jury comes in, I'll give my preliminary instructions. It'll be about 7 minutes, and then we'll hear the opening. How long does counsel want for the opening?
Mine will be 10 minutes.
10 minutes?
Similar amount, I would think.
Okay, thank you. Oh, okay. All right. I think we'll be ready to go in like 5 minutes or less. No, I'll be right back. Ladies and gentlemen of the jury, good morning. I hope you all had a nice weekend, and we're ready to get started. The first thing, as I said, is going to be a very short introduction for you about how a trial proceeds and what your duties are, and when I'm done, we'll then start with the opening address of the prosecutor. That's the first thing that happens. And the opening address is to give you basically a roadmap or an outline of what the government intends to prove. Obviously, either side can only call one witness at a time. So the purpose of an opening address is to sort of give you an outline of what the government's case is going to be. And it'll be short, probably about 10 minutes or so, just so you understand what the government expects to happen as the case proceeds. When Mr. Axelrod is done, then Mr. Cedrone can give an opening address at that time, or he can wait until the government is done presenting its evidence. That's up to him. After the opening address, then the government presents its evidence. And it presents its evidence by calling witnesses to the witness stand who testify under oath. And generally, the testimony of each witness has 4 parts. The first part is what we call direct examination by the party that called the witness. And that's done by a series of questions, and sometimes there might be exhibits that are used as well, where the witness will explain a document or something like that. When the direct examination is done, then we have cross-examination by opposing counsel. That And after that, then the government gets a chance for a redirect to bring out anything that the government thinks is appropriate to clarify something the witness may have said on cross-examination. And then the defense counsel finally gets re-cross-examination of the witness to challenge anything that the witness said on redirect. And after that, the witness is done and steps down. And then they call the next witness, and we go through the same routine until the government's ready to rest its case. And as I said, the government may use exhibits, and I think there are going to be exhibits in this case, and they will generally be shown electronically on the computer screen in front of you. But you will have a hard copy of all those exhibits when you deliberate. But this is an electronic courtroom, and it saves a lot of time for you to look at the documents on the computer screen rather than pass them around as we used to do. Now, it is very important for you to pay very close attention to what the witnesses say, because you are the judges of the facts. I'm the judge of the law, you're the judges of the facts, and you decide what the facts of the case are. And the testimony of the witnesses play a very important part in determining the facts. Now, you also have, in determining the facts, you have to pay attention to what we call the credibility of a witness. Credibility is a fancy word for believability. And that means, do you believe that the witness is telling the truth? But it's more than that. It's also, what weight do you want to give to the witness's testimony? Now, you're going to hear testimony from different people in this case, and they're going to testify perhaps about the same transaction in different ways. And it's for you to decide whose testimony you think is most worthwhile. And obviously, if you think the witness is lying, you may want to discredit that witness's testimony. But there may be witnesses who you're not sure who's lying or not, or who's telling the truth, or even you may think everybody's trying to tell the truth, but their testimony is different. And the best example I can give you of that is a silly example of a right-angle collision, which doesn't involve this case at all. So if you have a right-angle collision, you might have the two drivers, and they might have a different story about what happened, say who went through the red light or who went through the stop sign. But let's suppose you had two other eyewitnesses who were on opposite sides of the street, and they both saw this right-angle collision. And they came into court and they testified about it. Well, I wouldn't be surprised, and you may not be surprised either, if their testimony was very different. And they have no interest in the case. They're both trying to tell the truth. But they saw it from two different opposite angles. One was on one side of the street. The other was catty corner on the other side of the street. And they testified, with a lot of differences. Now, the jury, if a jury was hearing that case, the jury would have to decide, who should prevail, who should win. And the jury would want to take into account those two eyewitnesses. And you may conclude that they're all trying to tell the truth, but their testimony, as I said, is very different. So in determining credibility, you also have to consider a lot of other things, such as how's the witness's recollection? How does the witness appear on the witness stand? How does the witness answer questions? Does the witness have an interest in the outcome of the case? That's important. But does the witness has the witness been contradicted by statements that the witness has made at another time that may be different? How does the witness react to direct examination and cross-examination? And I'll have more to say about this at the end of the case. But this is probably your most important job, is to determine the credibility of the witnesses. And so therefore, you should pay very close attention to what they say. Now, the lawyers will be asking the question. Questions are not evidence. The evidence comes from the witness stand. And just to give you a silly example of that, if say that we had a witness today and the lawyer said, well, today is Tuesday, isn't it? And the witness would say, well, I'm not sure, I have to think, but no, I think it's Monday, okay? Now, we all know that today is Monday. So the fact that the lawyer asked the question, is today Tuesday, that's not evidence it's Tuesday. If the witness had said Tuesday, you would think the witness was just as mixed up as the lawyer, but the witness said it was Monday. So you could therefore say, well, the witness got the correct answer, even though the lawyer suggested it was Tuesday. Remember also that objections are not evidence, and the objections are entirely proper. And a lawyer is bound to make an objection when the lawyer thinks the question is improper. The objections are addressed to me, and I will rule on them, and you don't have to pay any attention to what my ruling is. And it's very important you not hold against anybody the fact that a lawyer made objection. That's their job. If I sustain the objection, that means the question was not proper under the rules of evidence, and the lawyer has to ask another question. If I overrule the objection, that means that my view is that the question is proper, and the witness should answer the question. And if something comes out that somebody moves to strike or ignore, and I tell you to ignore or strike it, then it's your duty to ignore or strike whatever ruling I may make. We want you all to be comfortable. As I said last week, that we take a mid-morning break and a mid-afternoon break. But if any of you need a break or you can't hear anything, raise your hand and I'll find out what the problem is and we'll deal with it promptly. Now, you've been given notepads and you are welcome to use them when you think it will help you have a note about what some of the witnesses may have said. Some jurors take a lot of notes, some jurors take a few notes, and some jurors don't take any notes. That's completely up to you. But the notes are for your personal use. You leave them here at night, and will be ready for you the next morning, and then they're for your use in your deliberations to help you recall things that you may have written down. If you think you want to write down a name or a date or some other kind of fact that you think is important, feel free to do it. However, I urge you not to try and write down everything, because it's also very important that you look at the witnesses and you pay attention to the questions and what the witness has to say, because I'll tell you that is going to be very important in deciding on credibility. And if you're busy writing down everything, you won't have that opportunity to really observe the demeanor and of the witnesses, which is an important characteristic of jury's duty. Now, as I said briefly on Thursday, the defendant in every criminal case under our Constitution is presumed innocent. The burden is on the government to prove the defendant guilty beyond a reasonable doubt. Now, I'll define those terms for you at the end of the case. So when the government is done presenting its case, then the defendant can make a choice whether the defendant wants to put the case on or not. The defendant is under no obligation to put on any case at all, but the defendant can put a case on if they want to. The defendant doesn't have to decide that until the government has done their case. So when the government's done its witnesses, I can't tell you what will happen because that's up to the defense, and then we'll find out what the defense will do. But just keep in mind that the burden is on the government, and that's why they go first. And that's why their argument goes first, and they go first in the presentation of evidence. Now, you've been given jury badges to wear, and I recommend strongly that you wear them when you're in the courthouse. And that is because people who are in the court system here, and the lawyers, the court officers, they know not to talk to jurors who have the badge on. They don't talk to jurors, and the way they know you're a juror is you have the badge on. So, and that'll go for the lawyers in this case and any of the witnesses. If they see you in the hallway or in the elevator, they're not going to say good morning or hello or anything like that. They're not being rude. They're not to have any communications with a juror of any kind. And so when you come in and go out, you can ignore them just as they're going to ignore you, and nobody will feel you're being rude. It's also very important that when you go out for recesses or you're home at night, you don't discuss the case at all with anyone, including anybody at home. If they ask you what happened today and how do you like it and what do you think, they say, the judge told us we're not allowed to talk about the case. So you just leave it at that. Now, when the case is over, you can talk about it all you want. But while the case is on, it's very important that you not discuss it with anyone, including yourselves, in the jury room. So when you take these breaks and you come back from lunch a little early, talk about the weather, talk about the Eagles, talk about Christmas, shopping, holidays, family, grandchildren, all those topics. You'll have lots to talk about. Don't talk about the case. Well, let me tell you why, at least one reason why. Because you're going to hear different witnesses. And you're at the very beginning of the case today. And I want you to pay attention, and you're entitled to form opinions in your own mind about witnesses and about things. But you on the jury, each of you may have different opinions, different reactions you have. And I think it's very important to keep it to yourself. because you don't know what the cross-examination is going to be, you don't know what the next witness is going to say, and it may turn your impression around 180 degrees. So you ought to keep those thoughts to yourself and not, if you say something to somebody else, that they might view that as attempt to influence you or sort of sway you to their view. And that's only proper when you have for the whole case and you start deliberating. That's when you talk to each other about the case and give your opinions about different witnesses and different facts and things like that. But while the case is on, it's very important you keep your thoughts to yourself and you not say anything to the other jurors, okay? As I said before, you're welcome to bring in a bottle of water or a cup of coffee, anything like that. All right, I think that completes the preliminary instructions that I wanted to give. So we're now ready for Mr. Axelrod's oath. Go ahead.
Thank you, Your Honor. Counsel, ladies and gentlemen of the jury. I introduced myself briefly a couple days ago last week. My name is David Axelrod. I'm an assistant United States attorney. Sitting with me at counsel table, Special Agent John Lyons of the FBI. And together we represent the United States of America. This case is about defendant Patrick Shelow's Ecuadorian oil scheme. That's right, Ecuador and oil. Those are two words you're going to hear a lot during this trial. During this trial, you're going to hear how the defendant Patrick Shelow created a scheme whereby he told his victims that they were investing in Ecuadorian oil. But what you're going to find out is that money wasn't going to Ecuadorian oil. Patrick Shelow treated his victims like his own personal ATM. Instead of inserting a card and punching in a pin, here's what he did. When he needed money, he created a company and he sold his victims worthless pieces of stock in that company. When he needed money, he created fake expenses and sent bills to his victims, told them they had to pay their share. And finally, when he needed money to pay off an IRS lien, he told his victims that he needed $350,000 to buy out another fake company out of the deal, to close the deal. That wasn't true either. Patrick Shelow created up a bunch of myths, falsehoods, whatever you want to call them, to deprive his victims of more than $1.2 million that they thought was being invested in Ecuadorian oil. Now I'm going to tell you, I want to talk to you about some of the cons that you're going to hear during this case. The big con you're going to hear is that the defendant told his victims that all their money was going towards this Ecuadorian oil scheme that was going to bring in hundreds of million dollars of revenue, and they were all going to be fabulously rich. Well, you're going to find out that that money went directly to Patrick Shelow. They paid for his lifestyle. They paid for a new $1 million house. They paid for another $1 million mortgage. They paid for cruises. So you're going to see all that. You're going to find out that the defendant Patrick Shelow told his victims he was a successful businessman. You're going to find out the company that he said he was the president of, Reserve Fuels, didn't file taxes in 2005, didn't file taxes in 2006, didn't file taxes in 2007, didn't file taxes in 2008. During the whole time of the fraud, from 2006 to 2008, Reserve Fuels, this defendant's company, never filed a single tax return. You're also going to find out that Patrick Shelow's office, his address for his company, was nothing more than a mail drop in North Carolina that collected junk mail. You're also going to find out that rather than being a successful businessman trading oil, as he told the victims, you're going to find out that from 2006 to 2008, he took in $1.4 million. 1.2 of it came from the victims, approximately 86%. Some of the other cons you're going to hear during this case is you're going to hear about Sigma Zug. Sigma Zug was this mysterious company that was associated with the defendant. And you're going to hear that at the end of 2007, Patrick Shelow told his victims that he needed $350,000 to buy out Sigma Zug. Well, you're going to watch that money go into Patrick Shelow's account. You're going to watch it go, part of it go right to the IRS to pay off a lien that Patrick Shelow needed to satisfy so he could sell his house in Florida. $1 million house, he was stuck with a mortgage, and he couldn't sell unless the IRS lifted the lien. Finally, one of the biggest and most unbelievable cons you're going to hear during this trial is the story that Patrick Shelow told his victims for why the Ecuadorian oil deal failed. After his victims had invested $1.2 million in this project, Patrick Shelow had the gall to tell them that it was their fault the project failed. And I'm not going to spoil all of the surprise for you, so you're going to hear the story, and it will shock you. Let me talk to you about some of the evidence that you're going to hear today. Well, actually, you're also going to hear that the defendant's cons weren't limited to what he told his victims. You're going to hear the defendant's accountant testify, and you're going to learn that this man, Patrick Shelow, also conned his accountant. And finally, he filed false documents under oath with the state of Florida. These are documents where he swore to tell the truth, and they were false documents that he filed with the state of Florida. Now let's talk about some of the evidence you're going to hear. First, you're going to hear testimony from the married victims of Patrick Shelow's scheme. Ted Amick is an ex-farmer. His wife is a trained nurse. And they were fortunate enough to come into a bit of money in the 90s. They were misfortunate enough to meet Patrick Shelow, who from 1995 to 2008 took about $2 million of their money with no return. Zero. Zip. Zilch. You're going to see the emails that he sent them. You're going to see the emails where he said he was going to Ecuador. But you're going to find out that wasn't true either. The closest Patrick Shelow got to Ecuador was sipping a beer in Cozumel, Mexico while he was on a cruise. You're going to see the victim's daughter testify. She's going to testify that her parents were so wrapped up in the scheme that they couldn't see through it. They couldn't see it was a fraud. But when she found out how much money they'd lost, she did what a rational person would have done. She sent the defendant 2 demand emails. She demanded to know how the money was spent. She demanded to know where the money was. Guess what? You're going to hear the defendant never responded. No accounting, no records, no nada. Zip, zilch. Now, in addition to the victims testifying, you all know that we live in a world now where there's increasingly a paper trail for everything. Emails are preserved. Bank records are preserved. Credit cards are preserved. Corporate filings that have to be filed with the state to have a corporation, they're all preserved. And you're going to get a chance to see all those documents. You're going to see Michelle Hoffman, who's a forensic accountant with the FBI. She analyzed the defendant's credit card reports. You're going to see that Patrick Shelow wasn't traveling to Ecuador in 2006 and 2007. He went on a few cruises. That's what you're going to see. You're going to see the bank accounts. And Patrick Shelow had a ton of bank accounts. And some of the money moved around in really strange ways. Agent Lyons is going to testify about his thorough analysis of the bank accounts. And you're going to see that none of that money went to Ecuador. It went to houses. It went to credit cards. It went to car payments. That's where the money went. You're also going to see emails that this defendant, Patrick Shelow, sent to his accountant. And these are very important because these were the side of the story that the victims couldn't see. These are the emails that tell you how the money was actually spent, not how Patrick Shelow said the money was being spent. And finally, you're going to see the corporate documents that this defendant filed with the state of Florida. You're going to see that he created this company, JAG, the company he sold the stock into to the victims. You're going to see that that company went inactive as soon as the money dried up. As soon as the victim's money was gone, so was that company. And you're going to see the other corporate documents for the other companies that this defendant supposedly ran. And just wait till you see these false documents. Excuse me. You're going to see so many misstatements, so many false statements, so many cons, so many dupes. You're going to be forced to ask yourself, why was there so much fraud? Was it all a scheme? Was it all a fraud? Those are the questions you're going to be asking yourself. At the end of the trial, that's the question that's going to be posed to you. Now, this defendant was indicted and charged with wire fraud because from 2006 to 2008, he took $1.2 million approximately from his victims with a scheme he created just to line his own pockets. At the end of the trial, I'm going to stand up in front of you, and at that point, I'm going to ask you to hold this man responsible for what he's done. I'm going to ask you to find him guilty of all the counts of wire fraud for which he's been charged with in this case. Thank you very much.
All right, Mr. Cedrone, would you like to open at this time?
Yes, I would. Good morning, members of the jury. My name's Mark Cedrone, and I represent Patrick Shelow, along with my colleague Aubrey Cedrone Emmerich. I want to hearken back to Thursday, when we engaged in this sort of uncomfortable process of picking you as a jury. Remember, we were all sitting on this side of the table. You were all sitting over there. We were looking at you. We were looking at papers. We were consulting it with each other. And then after about 2 hours, you each got plucked from your lives as retired police officers, as school teachers, as opticians, as engineers, or whatever you do. That process, the reason I start with that process, and I remind you of that, is that process was a critical function of this trial. That process was intended by the parties, including the government, to make certain that we pick jurors who would approach this case with the requisite level of seriousness that